involved in the particular situation. But it sounds as though there needs to be some type of investigation, not just by the guardian, but by the parent themselves to find out really what is going on. And that can be done through the discovery process by taking mom's deposition, because you're going to take her deposition to find out exactly what's going on and why is it happening before you proceed to trial. Because you don't want to be put in a situation where if this case does continue to head towards trial or court appearances, you want to be able to have your evidence set up and ready to talk to the judge so we can come up with either some type of settlement arrangement, or if not, then we proceed for trial.
Well, you just answered one of my questions, and this is going to be a follow-up, and this could probably be an entire show in and of itself. But you mentioned twice in both of these cases that we want to prepare ourselves to file for a motion. When you're doing that, when you think that things aren't proceeding correctly the way that they ought to benefit the kids after the divorce, if we can do this real quickly, what are the steps that the average person goes through? I would imagine they have to go talk to their lawyer to get this to file a motion for modification, and they would probably have to have some of their evidence all lined up even before they speak to their lawyer. But what is the process of filing for a motion?
Well, that's kind of a loaded question, but in general, what happens is the initial consultation, you come in, you select a firm, you meet with one of the lawyers who that firm assigns to either meet with potential new clients, and you explain to him or her what exactly are the situations, what's going on, what you're trying to achieve by coming in and talking to this particular firm. And then based upon that, that particular attorney will try to highlight what the issues are in the case and what some potential strategies are, and then what we're going to do from this point moving forward. Now, a lot of times the initial consultation is just to kind of get an idea of what's going on, and then the case is either taken on by that particular attorney or it's assigned out to another one of the lawyers in that firm. And that's really when you kind of dig deep into the case and you find out really what's going on. Now, what's beneficial in the initial meeting is not necessarily bringing just a flood of documents, but bringing some evidence or documents that you have that would be related to your particular case or cause of what you're trying to achieve. So in the past couple questions that we've talked about, the children really aren't doing well in school, or there's some type of instability going on. And so what you want to do is, if you have emails or text messages, you definitely want to come with names of counselors and teachers that you have spoken to that would be able to talk to that particular lawyer and indicate, here's what I see that's going on in class, and here's what I think is happening, and here's what needs to be done. Because you can get copies of, you will kind of want to back up a little bit. You want to bring in maybe report cards showing that at this particular time, here are the grades, here's what's going on, and here are the grades now. So you can show to the court that, there once was maybe A's and B's, and now there's C's and D's going on. And when there was A's and B's, here's what the situation was. Now it's changed to the current situation, and now we're dealing with C's and D's. So the grades are failing, the child's not getting enough sleep, the performance is below what the child should be achieving in school. And so when you talk to the lawyer, you want to explain what is going on so then they can make the legal strategies on what needs to be filed, when it needs to be filed, and where it needs to be filed. So once that's done, then the motion's filed with the court, and then you wait for a summons to be issued by the clerk. And then you want to serve the other parent with the summons, and then they have an opportunity to respond. Now, on a motion to modify, they're not obligated to respond by answer, so they won't be in default if they don't. Then you want to proceed with the case in chief. And so once you have that particular party served, you're going to want to send out discovery, which is what we've been talking about in the prior questions, dealing with potential interrogatories, requests for production of documents. You may even want to send out requests for admissions. Those are good tools to use to help facilitate your case and to either move towards settlement or to gear up and prepare yourself for trial. And so with that information, then you get a better grasp of what's going on in the case, and then you're better able to either draft a summons, or most importantly, you're better prepared for when you go into court. So when you make that initial court appearance, you can explain to the judge, here's the facts, here's the evidence that we have, and here's what we're looking for. And then it kind of puts you in a better position, not just for your client, but also in the court's eyes too, because you come well prepared.
So the first thing you want to do is, if you're considering filing for a modification, is get everything in order, get all your documentation so that you can show the attorney who you're speaking to, this is what I've got, and then you can proceed from there if there appears to be grounds for modification. And we could probably discuss the whole process of modification on a separate show, I would guess. There's probably...
Right. One thing that I wanted to add was that what the court's going to look at is what has been the substantial and continuing change in Missouri, what has been the substantial continuing change of circumstance from the date of the last order. And so that's what the court's going to look at. So it's got to be substantial and continuing. Because courts are like when you just come in and want to modify, right, especially if you just got divorced and you want to come in and modify a couple months later. Right. I mean, there's got to be, substantial and continuing change of circumstances. Okay. And that's when you meet with that particular law firm and that lawyer, they'll be able to properly and adequately advise you whether or not that they think that you have a particular case to be able to move forward in the courts.
Okay, so you want to be sure that this is something that's substantial and continuing, and that is worth the time of the court to bring it forward. We'll do one more question. My divorce decree was granted by the California Superior Court in May 2002, with a written stipulation for judgment between the parties specifying joint legal and physical custody for each of 2 children and spousal support that terminated with the children's 18th birthdays. Thus, there was no stipulation for child support. The ex-spouse now petitions for child support while keeping the previous decree intact, as the first decree in spousal support has been triggered by the first child's 18th birthday. Are there any prior cases that you know of or examples that you can suggest to deny this new petition?
Well, right, this particular person is talking about for the state of California. So dealing with California law, unfortunately, I don't know of any particular case in hand. But if you're trying to deny child support to a custodial parent in Missouri, the courts aren't going to look favorably upon you if you try to file a motion to dismiss. And what the courts will look at when they're awarding child support are the gross income of mom and the gross income of dad. And then if there's health insurance being paid, if there's other child support being paid by either parent. And then also what the court's going to take into consideration is the visitation time, because in Missouri, under what's called the Form 14, you get credit for any type of overnight visitation. And so when you're having a presumed amount of child support under the Form 14, then you subtract off the health insurance, and then you subtract off the credit that you get for visitation, and that's the amount of child support that each parent is to be liable for the children. Now, if a particular parent wants to modify the child support, then if you go according to what the Form 14 was, then they have a presumptive burden to prove that there has to be a change of 20% or more. Once that prima facie burden has been proved, then you can come in and try to modify it. But as far as trying to deny somebody child support, most courts won't look favorably upon that, especially here, at least I can tell you in the state of Missouri, that I would not advise anybody to try to deny the custodial parent child support. I mean, courts look at it that this is your child and you have a financial obligation to support this child. And in Missouri, it's till the age of 18, or if that child is enrolled in a full-time institution by October, their graduating year of high school, then it's to age 21. And there's other factors involved in where you can emancipate the child, whether or not the child is in full-time or whether or not the parent is receiving certified copies of transcripts. But that can be a whole show in and of itself. But there's certain other caveats to that particular statute when trying to emancipate, or what this person is trying to do is trying to stop child support. So I would advise somebody to come in and talk to a lawyer and tell them the situation, and then they'd be able to determine whether or not that particular child can be emancipated under the law, and then thus, therefore, child support will not be paid.
Yeah, a lot of times we do get questions on the site about child support, and so I think Dan is saying that when you bring something like that before the court, that's a very sensitive issue,
right?
And you better have good reason for wanting to proceed with where child support is concerned, and have everything lined up. This has been another edition of Dad's Divorce Live. We thank you for tuning in. We post a new edition every week, along with our 3 other shows on DadsDivorce.com. You can visit those other shows by going to the the video tab on the left side of the screen, and we encourage you to do so. There's a lot of information out there that will help you through the divorce, before and even after the divorce. For Dad's Divorce Live, my name is Rick Ortiz, and we had Dan Cuneo with us today from Cordell Cordell. Thank you.